Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Kent Landau, and welcome to Law You Should Know. Today we'll be discussing the top 10 myths of elder law and estate planning, and my guest is Melissa Negin-Wiener, and she's a partner with the law firm of Genser, Dubrow, Genser, and Kona. They're one of Long Island's largest elder law firms, and also they deal with estate and probate issues. Melissa, welcome back to Law You Should Know.
Thanks very much.
I know that you deal with many and all aspects of elder law and estate planning and also mediation of some issues. But today I'd like to focus on the myths of elder law and estate planning. And I understand the first myth is that a revocable trust protects assets. So explain why it's not true.
Okay. A revocable trust is typically used for the purpose of avoiding probate. When you place assets into a revocable trust, they're still considered yours for your lifetime. You can still access them for any reason. You can change the trust. You can undo the trust, for lack of a better term. And when you pass away, the assets pass directly to your beneficiaries. But when most people look to do some sort of planning to protect their assets for long-term care, Medicaid purposes, they want to put it into an irrevocable trust, because an irrevocable trust is what's going to take it out of their name for Medicaid planning purposes. So the irrevocable trust is what protects the assets.
In terms of entitlements?
Right, in terms of government benefits, yes.
Okay, and both the revocable trust and the irrevocable trust will continue to exist after a person has passed on?
When somebody passes away, the revocable trust, typically the assets are distributed to the beneficiaries. Same thing with an irrevocable trust. However, people can choose to leave their assets in continuing trust for their beneficiaries.
So it could be for a child or for a spouse or someone like
Correct.
Along those lines. Okay. And does everyone need a trust?
Not necessarily. When we sit down with clients, we look at what their assets are, what they're trying to accomplish, what they're trying to protect, their goals, and determine whether or not it makes sense for them to establish a trust. Again, most of the time we're doing irrevocable trusts, not revocable. So it depends, again, do they have long-term care insurance? Is Medicaid a possibility? And we gauge it based on that.
And so I'm glad you mentioned that. So an irrevocable trust, especially if they have assets, is important to preserve the possibility of Medicaid eligibility.
Exactly.
If they have long-term care insurance, they may not need to be as concerned about that?
It depends on the policy.
Okay.
If their long-term care insurance is such that it would cover the entire cost of, say, nursing home care, then perhaps they don't have that need. But most of the time we don't see policies like that.
Okay, so a long-term care insurance policy might just supplement Medicaid in
Correct.
some way.
Yes.
Okay. Changing to a slightly different area, is it also a myth that a joint account is counted 50% for Medicaid purposes?
Yes, this is one of the biggest ones out there, biggest myths out there. When an account is owned 50-50, in other words, we'll see an adult child come in and they'll say, okay, well, I'm joint on my mom's account, so only half of it is really hers for Medicaid purposes. Because in order to qualify for Medicaid, you can't have more than $15,150 in assets. So it's assumed by, the family members that only half of the account would belong to the Medicaid applicant. But the Medicaid rules say that the entire account belongs to the Medicaid applicant. So you have to be very careful when putting other people on accounts. Sometimes children will put their parents on their account as just for convenience purposes. And then we have to deal with that as an issue when applying for Medicaid because we have to document any accounts that the applicant's name is on.
Because technically they have the right to access that account and the money in it, even if it's not really theirs.
Correct.
This is going to be a very important one. It's a myth that a power of attorney can allow someone to make health care decisions.
So this is an interesting one. Power of attorney is financial. So when you name someone as your agent on a power of attorney, you're giving them the power to handle anything financial for you, from banking transactions to handling your tax returns, basically anything and everything financial.
And it can be very broad or it can be very limited, but it's not something to be taken lightly because you are giving them permission to act on your behalf.
Absolutely. The healthcare proxy is for healthcare decisions. It's interesting, though. I see a lot of people come in. Just today, I had somebody come in and they had a power of attorney to make healthcare decisions. And it was a healthcare proxy, but that's what it was being called. And I think that's what leads to a lot of the confusion.
So they're totally different animals. They serve totally different purposes.
Completely different.
And you may want your accountant or lawyer under some circumstances to have the power of attorney, but you may want a relative to have the healthcare proxy.
Sure, that's a possibility.
And you are going to need that healthcare proxy under different circumstances.
It really is very important for everybody to have a healthcare proxy. Once you turn 18, there's nobody really with the legal authority to make healthcare decisions for you. So,
and if you're unable to make them yourself, then it creates a big problem.
It can.
Okay. So you can prevent that problem by designating someone to make those healthcare decisions for you in a healthcare proxy.
Right.
And the power of attorney is there. I know it's a very complicated area, and your firm helps people to draw up power of attorneys when needed. But is there something in there to keep it in effect if, let's say, you're no longer competent to handle your affairs? So if the healthcare proxy got invoked, is there a power of attorney that can continue to be in effect at that time?
You need to make sure that if you're signing a power of attorney, it's a durable general power of attorney. The word durable basically is what's going to allow it to continue after somebody becomes incapacitated, which is when you really need it. So you have to make sure you look for that language.
Okay. And the healthcare proxy is only going to come into effect at that point. Otherwise, you're still making your own decisions.
Right. So the power of attorney for the financial, you could use that right away. But the healthcare proxy is only going to come into play when you're no longer able to communicate what you want.
Okay. And another very important myth for people to be aware of is concerning an IRS tax-free gift. So please explain that one to our listeners.
So the tax law says that we can transfer a certain amount or gift a certain amount of money to each person in our family every single year. It can be a child, their spouse, your grandchildren. So people can give away this money without having to file a gift tax return, okay? But what a lot of people don't realize is that gift actually is a gift for Medicaid purposes. So they'll come in to see me and say that, their mother has to apply for Medicaid, and she's given away, whether it was $10,000, $14,000, $15,000, depending on the year, the allowable.
Because the rationale is the government doesn't want you giving away your assets just so you can qualify for Medicaid.
Right. They're going to calculate a penalty based on what you've given away, and you're going to be ineligible for Medicaid for a certain amount of time.
And what is the look-back period?
So the look-back period is 5 years. Okay. It's 5 years for everybody applying for Medicaid in a nursing home setting. So when you apply, Medicaid looks back 5 years at all of your financial records to see what you've used your money for, what you've given away or gifted.
And that's why it's important for someone to come see you sooner before they have to worry or thinking about nursing homes or things along that line, because you can be most helpful to them in advance.
Absolutely.
Rather than a midnight crisis.
Right. We do a lot of crisis work.
Right. And another myth is what a will governs. So just explain that.
Sure. When people leave their estate to their children in a will and they say they want this person to have this much or that much or equally split, a lot of times they don't realize that any account that either has a named beneficiary or a joint account holder is not going to pass under that will. So there are cases where people have this whole grand plan in their will, but all of their accounts are either held jointly with one child who helps them with everything, or they have beneficiaries named. So we have to explain to them that those assets are going to pass to either the joint account holder or the beneficiary, so nobody's going to receive assets under your will. So it's just it's important for people to really make those designations when they want to, and if they want something to pass through their estate, to make sure that there's no beneficiary named.
And going back to account holders, it's important. Under most circumstances, does someone have another account holder on their account, let's say their checking account, so if they become incapacitated, that the bills can still be paid by whoever has that is on that account?
Sure, that's always helpful to have a joint account holder for the convenience purposes, like you're saying, of paying bills and things like that. A power of attorney would also be able to do those things. But the joint account holder, as long as it's understood that the joint account holder would receive that account upon the other person's passing, then it's fine.
And sometimes if you wanted to make a gift and make it convenient and easy, you could always set up, different, let's say, bank accounts and just put the other person you want as a beneficiary or as a second account holder?
Yes.
And if they're a beneficiary, they don't have any right to it while you're alive, and they only become the owner if something happens to you.
That's correct.
And that's if no title holders are left.
Correct.
Okay. And do you recommend that people, take advantage of that if they want to simply distribute assets, or have, if they want someone to have access to assets while they're alive, or to simply get them when they pass on?
Yeah, it's going to be definitely on a case-by-case basis. The family relationships, what we're dealing with as far as assets go, health, what the health is of the individual. So it's really going to depend. But there are definitely situations where it makes sense to have that joint.
And you'll go over all that with them. And, of course, this might also, if there's some certain account that might provide some money for their burial and their funeral expenses, because
Absolutely.
someone else might not have the money to write that check.
Exactly.
Another very important one is about whether you can own a home and be eligible for Medicaid benefits. So explain the myth.
Sure.
And the reality.
Sure. Most people think that you cannot own a home and qualify for Medicaid, but you actually can. You can own a home and qualify for Medicaid in the community, home care, or in a nursing home. However, in New York State, the value of the home cannot be over it's approximately $850,000 in equity in the home, or else you automatically don't qualify for Medicaid.
And what if the home is in two names? Do they use that, the reasoning, what you mentioned earlier with the bank accounts? Or let's say you own it with your spouse, you own it with a relative. Do they view you as owning the whole house?
It depends. If you own 50% of the property, depending on how it's titled, then you only own 50% of the property. If it's the joint ownership with a spouse, it can be the whole thing. Okay. But even though you can qualify for Medicaid with a house in your name, we typically don't recommend doing that because Medicaid can place a lien on the home. So as they're paying out whatever they're paying for from a healthcare perspective, they can place a lien on the home so that when the home is eventually sold, they can take back their assets.
And going back to one of your earlier points, that's why some people might want to set up an irrevocable trust to own the house and allow for you to live there.
That's one of the most common planning techniques that we have, especially on Long Island where the house values are so high. It's typically the largest asset a family has. will be to set up the irrevocable trust and transfer the house in.
And this way, the value of the house is shielded from the clause of Medicaid.
After the 5-year look back is passed.
Okay. And that's another reason someone should come see you sooner and do that sooner, because it may be too late and it's going to be harder to do it in the middle of the night.
Exactly. The planning is so important.
And they would get a lien on day one?
No, usually it takes the counties a little bit of time to catch up, but they do it.
Okay.
They do catch up.
We're going to take a short break, and then we'll continue our discussion about the top 10 myths of elder law and estate planning with our guest, Melissa Negin-Wiener, who's a partner with the elder law firm Genser, Dubrow, Genser, and Kona, with offices in Melville, Long Island, New York. And, of course, they have clients all over Long Island.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. Today we're discussing the top 10 myths of elder law and estate planning, and our guide for this journey is Melissa Negin-Wiener. She's a partner with the elder law firm of Genser, Dubrow, Genser, and Kona. They're one of the largest elder law and will and estate attorneys and law firms on Long Island. Melissa, another myth is that life insurance is not part of your taxable estate.
Right. And indeed it is. So the value of the life insurance will be part of the estate when you're doing calculations to see whether or not you have to pay estate taxes.
And this is even if there's beneficiaries on that life insurance.
Right. The value is still pulled back in.
Okay. But if there are beneficiaries, then the proceeds will go to them. If there are no beneficiaries, then it would become part of your estate.
Right.
So what do you recommend that people do about that?
Well, with the changes to the estate tax laws, really, the numbers have to be quite high, but we do different types of estate planning, gifting, setting up life insurance trusts. There are all kinds of different techniques that are used to try to help deal with the estate taxes.
And just to bring that point home, there are many different tools that you can help utilize for your clients to help them keep their home, keep themselves in the home, to be eligible for Medicaid should they need it, and also to minimize estate taxes.
Absolutely.
And what about another myth is that an IRA is countable resource toward Medicaid?
Right. So a lot of people, when they look at that $15,150 number that you're allowed to have and qualify for Medicaid, they don't realize that your retirement accounts don't count towards that. So people can have a 403B, a 401K, an IRA with a couple $100,000 in it and still qualify for Medicaid as long as their assets that are countable, like their checking savings, money markets, things like that, are below the $15,150.
And this also presumes they have no income or minimal income?
Well, Medicaid rules as far as income goes are a little bit different. They the IRA or the 401K, 403B, once you turn 70 and a half and you start taking your minimum distribution, if you go on Medicaid, Medicaid requires you to maximize your distribution. So they have their own charts to do the calculations. It's a larger number. So what they then do when they're calculating the Medicaid budget, they're looking at the application, they take that maximum distribution for the year divide it by 12, and make it part of a person's monthly income.
So a big IRA or 401k payout may hurt you.
Yes.
At that point.
If your retirement account is large enough that the income that's kicking off with the maximized distribution is somewhere near the rate that the nursing home is, the cost, or the home care agency, there might be some other techniques you want to use to.
And then maybe you benefit from long-term care insurance if you're eligible for that.
Yeah, if you're eligible, sure.
And this, we may have touched on it earlier, but another important myth is that a young person does not need a health care proxy, a power of attorney, or living will. Explain why that is a myth.
This is a super important one. So people always kind of equate these documents to age, health, or wealth. Right. They really have nothing to do with any of it. Once you turn 18, like I had said earlier, there's no longer anybody with the legal authority to handle finances for you, to make healthcare decisions for you. So really, once a person turns 18, they should have a power of attorney healthcare proxy in place. We just had a program at our office where we were doing healthcare proxies and powers of attorney for college-age students, because parents don't realize they send their kids off to college, they're paying the bill for college, their child is still on their health insurance plan, but they don't have a right to information. So you have a child across the country in college and there's some sort of accident or incident. If that child can't give the doctor's permission to speak to you, you don't get any information.
And these things can always be changed at any time until they're activated.
As long as somebody has capacity to make a change, they can change a document at any time.
Okay. And what about the myth that a disabled person cannot inherit money without losing government benefits?
So many times when we're doing an estate plan for somebody or a Medicaid plan, if they have a child who's disabled, there's a lot of concern about that child coming into money because many times the child is also on government benefits. So there is something called a supplemental needs trust that we utilize where assets can be left to a child who might be on some sort of government benefit that's resource-based. And that supplemental needs trust is there just to supplement that person's benefits as opposed to being there in place of them. So supplementing instead of supplanting the Medicaid benefits that the disabled child might be on.
But this is something set up so to govern the use of those assets. So it's not really available to the disabled person.
Right. There'll be a trustee named for the supplemental needs trust, and that trustee will be able to use the monies on behalf of that disabled person. But it won't knock them out of the box for their own government benefits. And because it's monies coming from another individual, not their own money, there won't be a payback provision where Medicaid has to get paid back at the end of their life. It could then, if there's money left over, be passed on to another family member.
We've covered the top 10 myths of elder law and estate planning. In a moment, I'm going to give you a chance if you briefly wanted to cover any others that you hear about from time to time. But first, give us the website for your firm where a person can read about these different areas and learn about different elder law terms and issues.
Our website is www.genserlaw.com.
Okay, and that's GENSCR.
Yes.
Okay. And there's a lot of resourceful information on that site.
Yes, absolutely.
Are there any other myths you'd like to comment on? We have a moment or two left in the program.
Mostly what I see as far as myths go is what people don't understand when they're looking to apply for Medicaid. And it's not, we talked about some of them here. We talked about the irrevocable trust, versus the revocable trust. We've talked about what counts as an asset and what doesn't. Also, one thing that a lot of people don't realize is that if you are married, you can transfer all of your assets to your spouse.
And is that subject to a look-back period?
Well, there's always a look-back, but if they see that all the assets went to your spouse, they're not going to penalize you for making those transfers.
Even if that's in the 5 years?
Even if it's in the 5 years and even if the person's in a nursing home.
And children don't count. It has to be to your spouse.
It has to be to your spouse. If you have a home and you have a child living with you for at least 2 years prior to your admission to a nursing home, you can transfer the home to that child with absolutely no Medicaid penalty.
So I think that's a very important point, and most people are not aware of that.
Yes.
So if you have a child living with you, whether they're helping you or they're just living with you because they have nowhere else to go, just tell us about the transfer.
It's called a caretaker child exemption. So the requirements are that it is a natural child, so we need to provide birth certificate, adoption papers, legal child, and we have to show that they've lived there for at least 2 years. So usually we give the top page of the tax return to show that that's their address, and if we can do that, the parent can transfer that house to that child with absolutely no Medicaid penalties whatsoever.
And they get transferred other assets to them as well?
No.
Okay.
The caretaker child exemption only applies to the home.
But it's a very important device for taking care of the home and having it not count on that look-back period.
Exactly.
Okay.
And the idea behind it is that child has probably kept the parent out of a nursing home for those 2 years.
Okay. I wish we had some more time, but just give us your firm's website again.
Sure. It's www.genserlaw.com.
And we've been talking to Melissa Negin-Wiener, who's a partner with the law firm of Genser, Dubrow, Genser, and Kona. They're one of Long Island's largest elder law and will and estate firms. And if you look at their website, you can find many of the points we've been discussing today and also much more information about elder law issues and also estate issues. Keep in mind, whatever you've heard is advice only. You must get legal information from your own financial planner or attorney. Please join us next week at this same time for another program on Law You Should Know. And if you missed any part of today's program, you can find it by searching WHPC on iTunes or Spreaker. That's SPREAKER.com.